Mr. Kumar, as the ex-law minister of the country, we've seen the government is now jumping into the debate. We've seen the Prime Minister has in his personal assurance stated in a 3-page affidavit that's been filed by the MHA that they believe this law needs to be re-examined. But we also remember that there is statements that have come in from the government also stating that there are certain reasons that this law needs to be on the statute books. The Attorney General of India, Mr. K.K. Venugopal, had very, very clearly stated that there are times it's misused, like in the state of Maharashtra, when Navneet Rana and her husband were sent to jail. But he said this law is very much needed when it comes to protecting India's national sovereignty.
Well, this has been a classic argument that has been repeated ad nauseum for the last several years. I think the Indian nation is not a banana republic. There are any number of laws that can prevent people from continuing or indulging in seditious activities. But the rigor of the law is such that its proclivity of being abused has been now demonstrated beyond any reasonable doubt, and that is itself a ground to remove the law. As I said earlier, giving guidelines in the matter of implementation of a law scarcely serve their purpose. We have seen that in the custodial torture field. Although Supreme Court has given binding guidelines regarding custodial torture, yet custodial torture continues unabated. And similarly, without a repeal of the sedition law in its present form, there is no escape from its abuse by various governments. And this has been demonstrated in the last several months and several years beyond an iota of doubt. So I think it would be consistent with India's commitment to human rights, to Article 21 of the Constitution, and to the idea of a humanitarian democracy that such oppressive, colonial, archaic, and easily abusable laws to be taken out from the statute book.
Sir, but a political question, you would agree that the misuse of this law has been secular in the sense that every government of every political color has used it, and Congress, having been for the longest time in power over the last 70 years, is an equal culprit.
Now, I don't think there's any comparison here, with the utmost respect to you. The kind of abuse that we have seen in the last several months and recent years is absolutely unparalleled. Yes, there could have been abuse in the past as well. And that is why in Kedarnath's case, the Supreme Court did indicate that there was need to temper the law. I'm not saying that there would have been no aberration earlier, but what we have seen in the last several months is absolutely unforgivable and without a parallel.
But then Congress never thought of repealing the law, sir.
Well, I don't know what happened at that time. The fact is that for any reason, and I will not be able to know what all the reasons were, but till now the law on sedition is on the statute book. But look, there comes a time in the nation's history when a tipping point comes, when the nation's endurance is on test. And if this is the time, then I'm glad that the Prime Minister has taken the initiative himself, as the report says, that it is on his intervention that this affidavit has been filed. It is a progressive intervention, and I think one should give it the due. But I only hope that this does not, the process of review does not get delayed forever, and I hope that this is not to be used to deprive the Supreme Court of its plenary jurisdiction to review the legislation. And I think probably, I'm not sure, I have nobody to advise the Supreme Court or the government, but maybe one of the way out could be that the Supreme Court go ahead with the hearing of the case and reserve its judgment till the government comes out expeditiously with the conclusions of its review process. The nation can't wait any longer for this law to go.
Mr. Kumar, as we are stepping in to see that crucial hearing in the Supreme Court on sedition law, what has to be seen is that the government has reasoned instances of abuse of Section 124A does not justify
judgment of the 4-decade-old Kedarnath case. Now, what I really need to understand and gather here is
there is a need for sedition, possibly because
is being targeted several times over. Now, there is instances of misuse like we've seen in the state of Maharashtra. However, does that make us ensure that there need to be guidelines, or do we just do away with the law that is needed for India's national integrity?
Look, I think I elaborated at some length that in the experience of the nation, guidelines by themselves may not be enough. And we have seen the inadequacy of the guidelines in the matter of preventing custodial torture. But today, the extent of the abuse of sedition law has come to a point where in the national consciousness, continuing with an archaic law, which was a colonial law, in a free country seems to be absolutely unnecessary. There are enough laws in the country under the penal code, under the UAPA, and so forth and so on, which can be used in exceptional circumstances of absolutely foolproof case of seditious activity. Opposing a government does not tantamount to sedition by a long shot. And therefore, the law as structured today, the law as applied today, the precedents established under the law make libertarians and humanitarians very apprehensive about the legitimacy and the continuation of this law. Therefore, now that the government has taken the first step, I think we should support the repeal of this law or a comprehensive redrafting of this law so that there is absolutely no chance of its blatant abuse, as in recent times.
Sir, again, a political question, again, a political question, sir. The Congress party brought in TADA, then went against it, then brought in UAPA with amendments and incorporated some elements of TADA in UAPA. What would be the Congress party position on sedition law? Because when you were in power, you never thought of repealing it.
Well, look, I don't speak for the Congress party, as you know. I have resigned from the membership of the Congress party. But I think, from whatever little I understand, Congress is a liberal democratic party, and that is what its proclaimed philosophy has been. I don't think congressmen can support sedition law in its present form. I don't think Congress will support sedition law. And I believe that there are any number of other legal avenues available to any government to prevent an obviously seditious activity against the unity and integrity of the country. So I think the liberty and dignity of the individual, which can be ensured by preventing the oppressive and unlawful use of the sedition law, is a prime priority at this point of time of the country.
Right. Thank you so much, former Law Minister Ashwini Kumar there, putting across his position, distancing himself from the Congress party, but supporting the Prime Minister for the call taken on review of the sedition law. On that note, let's listen in to BJP's Nalin Kohli on how he sees the initiative coming in from the government after Prime Minister's push.
Obviously, this should be seen as a positive development. Let's not forget that over the last 7.5, 8 years, Narendra Modi ji's government has worked to remove over 1,500 archaic laws that were not required. These statutes or these sections were not required. Therefore, there is an attempt of the government consistently to ensure that the environment should be such that the business community, or in this case individuals, whatever needs to be done to make it easier, that should be done. Now, with regard to the sedition law, it has been held to be constitutionally valid by a Supreme Court judgment in the past. The matters before the Honorable Supreme Court. When the government puts out its view in such a positive manner, it means it obviously wants to study it either by the executive route or the legislative route, rather than see it being examined by the judicial route in terms of a conflict between two sides. So one should view it as a positive development, and we should await further details on it before anyone starts resorting to politics on it.
All right, a political hot potato there, the sedition law and its review, with the Prime Minister giving a green signal to the possibility that India could be phasing out its colonial era archaic sedition law, a debate has engendered along the political lines as well. So we had Ashwini Kumar, former Congress leader, now distancing himself from the party but welcoming what the Prime Minister has done. Rhythm, what has changed between Kedarnath and now, between 1962? All right, KK Manan, senior lawyer, senior advocate, is with us. Rhythm, would you want to take a question with him?
Let's also go across, like Abhishek is saying, to Mr. KK Manan. Mr. Manan, thank you for being with us as one of the topmost jurists, one of the top lawyers in the country. I ask you, you must have done many cases, Mr. Manan, where you yourself must have seen why the sedition law is important. The central government a few days ago has said that we already have the Kedarnath verdict, which is good law. It needs no reconsideration. However, because of this uproar, the Prime Minister today has personally stated in the Supreme Court in an affidavit filed by the MHA that this law is going to be re-examined by a forum. How do we look at this, Mr. Manan? Because on the one hand, the central government is absolutely clear in the court that this law needs to be on the statute books.
Ridhamji, in fact, if you remember that I told at your channel number of times that every law should be re-examined time to time because the society is being changed time to time. Law is to be, I can say, look into afresh. Even the whole IPC, Indian Penal Code, Indian Evidence Act, Criminal Procedure Code, CPC, Civil Procedure Code. Likewise, this sedition section 124A, 153A, 505, IPC, all these sections require look into again and re-examine again. And I told number of times, especially on your channel, number of times, then it is, I can say, good news for the nation that the Honorable Prime Minister himself has considered and wants to repeal this law and re-examine the law, and he may enact another law instead of the present law. That is a very good news for the, especially the prevailing circumstances. We have seen how the Punjab has behaved.
चेयरपर्सन है और हर व्यक्ति जो मेंबर है उस पार्लियामेंट हाउस का, उनका उतने ही अच्छे तरीके से वो ध्यान रखते हैं. पूरी डिटेल मैंने उनको बताई, लॉकअप से लेकर जेल में, जेल के बाहर, जैसे जैसे अरेस्ट हुआ, जिस तरीके से कार्रवाई हुई, किसके आदेश पे ये झूठे ऑफेंस दाखिल किए गए, किसके आदेश थे, और सभी चीजों पे मैंने बात की. जैसे मुंबई के जो कमिश्नर हैं पांडे जी, उन्होंने किसको आदेश दिए और किस तरीके से डिपार्टमेंट ने कार्रवाइयां की हैं, सब चीजें उन्होंने एक तारीख मुझे दी है 23 तारीख को. मेरी जो भी कंप्लेन है उसके सुनने के लिए एक डेट ठहराई गई है और प्रिविलेज उसकी पूरी जानकारी मुझसे लेगी, लेखी स्वरूप से भी और मेरे जबानी से. तो मुझे लगता है ये सब चीजें उनको दी हैं और न्याय की अपेक्षा मैंने पूरी रखी है बिरला साहब से कि इस पे अगर वो दोषी हैं और दोषी पाते हैं तो उन पे जरूर कार्रवाई होगी. और जो तरीके से मेरे साथ व्यवहार हुआ वो हर चीज डिटेल्ड में मैंने बिरला साहब को बताई और उन्होंने बहुत दुख व्यक्त किया है कि ऐसी घटना कोई भी मेंबर के साथ में कभी ना हो और स्पेशली महिलाओं के साथ ऐसा होना ये कोई अच्छी बात नहीं है. तो उन्होंने सुनकर 23 तारीख को प्रिविलेज के सामने मेरी पूरी बात एज ए स्टेटमेंट रखी.
किन का नाम लिया है आपने? जैसा कि आपने सीपी का जिक्र किया था, किन नेताओं का, अधिकारियों का जिक्र किया है आपको ये शिकायत करने वाली?
आज मैं आपको इतना बताऊंगी कि बिरला साहब से मेरी मुलाकात हुई है और जिन जिन की भी कंप्लेंट्स मैंने देनी है उसमें सभी के नाम, सीपी है जो मुंबई के, उनके अगेंस्ट भी मैंने बहुत कुछ उन्हें जो बताया है, जिनके आदेश पे ऐसा हुआ है, सभी के नाम उस कंप्लेंट में मैं जरूर बताऊंगी. जो सच होगा वो मैं जरूर प्रिविलेज के सामने रखूंगी. और इस सभागृह की एक सदस्य होने के नाते इस सभागृह पे पूरे देश को विश्वास है और उसकी मेंबर को भी विश्वास है.
कोर्ट ने कारण पूछा है आपसे कि क्यों ना आपकी जमानत रद्द कर दी जाए, तो कोई लिखित जवाब
आज मैं बिरला साहब को मिलने आई हूँ. उस विषय पे मैंने आपको बताया जो कंप्लेंट मैंने की है, उसके लेखी स्वरूप में भी मेरा स्टेटमेंट बोलेंगे. आपण नंतर बोलू लीलावतीबद्दल. खूप सारे मुद्दे आहेत. माझी पर्सनल जर कोणाला एवढी काळजी असली तर माझ्या घरात येऊन मला विचारावं की काय तकलीफ आहे, काय त्रास आहे. मुख्यमंत्र्यांनी पहिले त्यांची रिपोर्ट द्या आणि महिलाची रिपोर्ट विचारण्यासारखी गोष्ट कृत्य करू नका. मुख्यमंत्री त्याच्या पदाचं भान ठेवा तुम्ही.
All right, Swapnil Kothari joining us from Mumbai. Swapnil, what happens to offences against the state? Do we have provisions on statute books that can deal with offences against the state in the absence of a sedition law?
Oh, absolutely. There'll be several ones in the Indian Penal Code: waging war, 121, I believe that's the section, if my memory serves me right. This is 124A was sedition, and I'm sure it's interspersed in various acts under the UAPA and MCOCA, which is the Maharashtra Organized Crime Control Act. UAPA is Unlawful Activities Prevention Act. So those will all have sections which will deal with offences against the state. But I don't think that it's going to be as easy to repeal the law just because the centre has agreed to re-examine and is on the same page more or less as the petitioners. Otherwise, there'll be no battle before the Supreme Court. So this battle before the Supreme Court is not going to be very simple. That the petitioners say that this is a colonial law, so let's abolish it. And then the centre says, okay, since the Prime Minister has told us we should go ahead and do that. Sorry, that's not the way it's going to work. At best, I think the centre will say that let it remain. And,
Yes.
Let's tailor it down to some 4-5 events which amount to sedition. And the Supreme Court usually what it does is either repeals, it either retains the law or it reads down the law. So I'm sure in this case, it looks to me that it will read down the sedition law in the sense it will still narrowly tailor it and distinguish it or
I agree.
overrule
I agree.
Kedarnath's judgment to that extent.
Swapnil, as we're going to be waiting to see whether the Supreme Court will be going ahead with the judicial review after this affidavit, we also want to go across to Ashwini Dubey, lawyer, who's joining us on the phone line. Ashwini, how are you looking at the recent developments where after the centre has told the Supreme Court they don't believe there needs to be a judicial review of Section 124A, the Prime Minister has come into the debate and said colonial baggage needs to be shed. Do we take this as a hint that there's possibly a reading down of 124A that could happen, or do we believe that it's a forum that will be re-examining, as the Prime Minister says, the current section in its current form?
It appears from the affidavit that the government of India wants to revisit and wants to bring certain new guidelines so far as the 124A is concerned than the sedition. The affidavit which has been filed before the court, government says that the decision was in line with Prime Minister Narendra Modi's vision to shed colonial baggage in the 75th years of the independence. And given that the government is going to reconsider the law, the affidavit requests the Supreme Court not to look into the matter at the moment. So if we look into the intention which has been given in the affidavit, that the government of India is planning to reconsider it. One. Secondly, if you remember, 2 days back, the learned Attorney General of this country says that, look, since there is a 5 judges bench of the judgment in Kedarnath, where certain principles have been laid down, but there is, as of now, the time has come where we have to revisit this law. Revisiting certain guidelines may be fixed so that it should not be misused at the behest of the state. The government of India, what they have submitted in the affidavit, that they are fully cognizant of the various views being expressed on the subject of sedition and also having considered the concerns of civil liberties and human rights. That's the important which they have mentioned. And they have said that while committed to maintain and protect the sovereignty and integrity of this great nation, and therefore has decided to re-examine and reconsider the provisions of Section 124.
Ashwini, one of the things, like you're saying, they'll have to see is whether colonial baggage versus misuse versus civil liberties and human rights, all this taken together. But first, I want to go across to Ujjwal Nigam, senior advocate joining us from Mumbai. Mr. Nigam, you've been at the forefront of several cases. You've been the special public prosecutor in the Kasab case, and we all know that you would know things about national integrity in very clear.
Look at this when the Prime Minister says that we're going to re-examine the sedition law.
This is I must welcome this step taken by the central government for 2 reasons.
Firstly, the government would like to revisit the whole law on sedition that is embodied in the section 123A of the Indian Penal Code. Now, secondly, there was a main allegation against the state law that it is being spreadly used by the certain state government as well as the central government against the some people who have been deprived their voice against the government. Now, see, this is a very positive step taken by the government, but at the same time, the main allegation against the state law on the sedition that it has been misused. So, no doubt, the government has made a statement that they would like to revisit the law, meaning thereby also that government would like to put certain checks and counter checks in section itself so that it can't be misused. Every kitchen has a cockroaches, but if we would like to have a good food, then we have to have a kitchen in our house. So only in order to remove the cockroaches, we use the strong insecticide. Similarly, I think that the government may also consider to put certain checks and counter checks in the state law so that nobody should dare to misuse the state provision of law. But let us see what government comes with the proposal.
That's what we need to see, Mr. Nikam, whether guidelines would be there, whether there'll be any provisos. Thank you for being with us.
All right, Rhythm, on that note, we will take a short break. But on the other side, no immediate re-arrest for the Ranas.